the Nixon impeachment as really about his motives in defying Congress over the country's foreign policy in Vietnam. Again, all of that may be true, but it has nothing really to do with impeachment. Not only that, it's also bad history. As recognized 65 years ago by then Senator John F. Kennedy in his book Profiles in Courage, President Johnson was saved from removal from office by one vote, and thus by one courageous senator who recognized the legislative overreach that the Tenure of Office Act represented. Quoting now from Senator Edmund G. Ross in Profiles in Courage, who explained his vote as follows, quote, "The independence of the executive office as a coordinate branch of government was on trial. If the president must step down upon insufficient proofs and from partisan considerations, the office of the president would be degraded," close quote. So too here. Contrary apparently to the fashion now, Senator Ross's action eventually was praised and accepted several decades after his service, and again many years later by President Kennedy as a courageous stand against legislative mob rule. Professor Dershowitz will have more to say about one other courageous senator from that impeachment, more on that later. For now, the point is that our history demonstrates that presidents should not be subject to impeachment based upon bad or ill motives, and any thought to the contrary should strike you, I submit, as exceedingly dangerous to our constitutional structure of government. If that were the standard, what president would ever be safe by way of impeachment from what Hamilton decried as the, quote, persecution of an intemperate or designing majority in the House of Representatives, close quote. The central import of the abuse of power article of impeachment, indeed when added together with the obstruction of justice article, is a result not far off from what one citizen tweet I saw back in December described as Article 1, Democrats don't like President Trump. Article 2, Democrats can't beat President Trump. President Trump is not removable from office just because a designing majority in the House, as represented by their managers, believes that the president abused the power of his office during the July 25th call with President Zelensky. The Constitution requires more. To ignore the requirement of proving that a crime was committed is to sidestep the constitutional design as well as the lessons of history. Now, I know that many of you may come to conclude, or may have already concluded, that the call was less than perfect. And I have said on any number of occasions previously and publicly that it would have been better in attempting to spur action by a foreign government in coordinating law enforcement efforts with our government to have done so through proper channels. While the president certainly enjoys the power to do otherwise, there is that a crime was committed. That action is to, as we have now witnessed. After all, that is why we are all here. But it is another thing altogether to claim that such conduct is clearly and unmistakably impeachable as an abuse of power. There can be no serious question that this president or any president acts lawfully in requesting foreign assistance with investigations into possible corruption, even when it might potentially involve another politician. To argue otherwise would be to engage in the specious contention that a presidential candidate, or for that matter any candidate, enjoys absolute immunity from investigation during the course of a campaign. I can tell you that's not the case from my own experience. I did so during 2000 in investigating Hillary Clinton while she was running for office to become a United States Senator from New York, to which she was elected. My point simply is this. This president has been impeached and stands trial here in the Senate for allegedly doing something indirectly about which he was entirely permitted to do directly. That cannot form a basis as an abuse of power article sufficient to warrant his removal from office. Turning now to the second article of impeachment. As we argued in our written trial brief, at the outset it must be noted that it's at least a little odd for House managers to be arguing that President Trump somehow obstructed Congress when he declassified and released what is the central piece of evidence in this case. And that's, of course, the transcript of the July 25th call, as well as the call with President Zelensky that preceded it on April 21, 2019. Release of that full call record should have been the end of this claim of obstruction, but apparently not. Instead, again relying on United States versus Nixon, House managers have proffered a broad claim to documents and witnesses in an impeachment inquiry, notwithstanding the Nixon court's limited holding that an objection by the president based on executive privilege could only be overcome in the limited circumstances presented there, where the information sought was also material to the preparation of the defense by his co-conspirators in pending cases awaiting trial following indictment. In other words, a defendant's Sixth Amendment right to a fair trial in collateral proceedings was what the court actually found dispositive in rejecting the president's claim of privilege to prevent Congress from gaining access to the Watergate tapes. All subsequent administrations have defended that narrow exception against any general claim of access to executive branch, confidential communications, documents, and witnesses who are the president's closest advisors. Thus, it should be a matter of accepted wisdom and historical premise that a president cannot be removed from office for invoking established legal rights, defenses, privileges, and immunities, even in the face of subpoenas from House committees. Back in 1998, Professor Tribe called out any argument to the contrary as frivolous and dangerous. House managers respond now by arguing nonetheless that the president has no right to defy a legitimate subpoena, particularly, I suppose, when their impeachment efforts are at stake. And thus, it is an issue rising to the level of an interbranch conflict that in our system of government, only accommodation between the branches and ultimately courts can finally resolve. The House chose to forego that course and to plow forward with impeachment. House managers cannot be heard to complain now that their own strategic choice can form any basis to place blame on the president for it, and worse yet, to then impeach him on that basis and seek his removal from office. That's no basis at all, as Professor Jonathan Turley persuasively has explained. Compliance with a legitimate subpoena is enforced over a claim of executive privilege or presidential immunity only when a court with jurisdiction says so in a final decision. In sum, calling a subpoena legitimate, as House managers have done here, does not make it so. An analogy taken from baseball that I believe the Chief Justice might appreciate makes the point. A longtime Major League umpire named Bill Clem, who worked until 1941 after 37 years in the big leagues, was once asked during a game by a player whether a ball was fair or foul. The umpire replied, "It ain't nothing until I call it." Well, I say the same thing to Chairman Schiff now. It's not a legitimate and therefore enforceable subpoena until a court says that it is. Preceding the Clinton impeachment, and indeed in response to demands not just from the Whitewater Independent Counsel, but also from several other of the independent counsel investigations that were ongoing at that time, and again, I know, I was in one of them, the White House repeatedly asserted claims of executive privilege. Many of those claims were litigated for months, not weeks, and in some cases for years. So when I hear Mr. Schiff's complaint that the House's request for former White House counsel Don McGahn's testimony, grand jury material, and other documents has been drawn out since April of last year, I can only say in response, boo-hoo. Did I think at the time that many of those claims of privilege were frivolous and an abuse of the judicial process? Of course. And indeed, that was the determination of the House Judiciary Committee during the Clinton impeachment. What did they do about it? Nothing. The committee properly concluded then that those assertions of privilege, even if ill-founded, did not constitute an impeachable offense. Did I believe that the Clinton administration's actions in this regard had adversely impacted our investigation? You bet I did. And I said so in the final report. But never did I seriously consider that those efforts by the White House, although endlessly frustrating and damaging to the independent counsel's investigation,